Thank you very much to the organisers for having given me this opportunity to talk to you. There are a number of points which remain unclear. This, of course, is not intentional, but there are a number of points which remain unclear. I'd like to explain the kind of approach that I adopt. I'm a journalist. I'm specialised in German family law. I've got a master's in welfare rights and protection of minors. And my initial involvement in the issue of the Jugendamt is that I'm a linguist specialised in bilingualism as well. Now, these two aspects, the legal aspect and the linguistic aspect, are closely linked, and they're very important to understand what's going on. In fact, it's precisely because of the way in which the terms are translated that the German system manages to appear just the same as all the others. It conceals discriminations which are actually inherent to its structures. Perhaps I can explain this more clearly. I've actually given the interpreters a brief glossary in the PowerPoint of how I wish to have the terms translated, with the main nouns which will help us to understand the way in which these systems vary. So please, as I've already insisted, do not translate the term Jugendamt, simply say Jugendamt in German, in all the other languages too. And I hope that in future, when we talk about this issue in the Petitions Committee, that this terminology will be used, because otherwise we won't be able to all be talking the same language and we won't understand each other. The German minister replied to questions put by the last working group on child welfare, and that was from the Petitions Committee, and we received this reply with various different language versions. But what was most striking was the answer that we managed to receive from the German minister in German. And that too was translated but only into English. So that's not necessarily terribly useful, certainly not the way that it's been translated. That's not because the translators aren't good at translating. It's simply because there are legal tropes which exist in Germany and they don't exist in other countries, which makes them impossible to translate. A baguette, for example, cannot be translated into Italian. You just call it a baguette, and that's that. And it's the same here, I would say. So you should not translate these terms, I would say, but explain them, not just in linguistic terms, but above all in legal terms, glossing the way in which the system is organized in Germany. People within the German systems can certainly criticize that system well, but our system is very different. All of our systems are different. And the problem is that these differences mean that there are serious sources of discrimination. For example, there is that famous term, Verfahrensbeistand. Now that shouldn't be translated. I've seen the translation guardian ad litem or legal guardian. I would say that that is not correct because, legally speaking, the powers of the Verfahrensbeistand are distinct from those of a guardian. They don't exist in our systems. In Italian, it's often translated with a term that is equivalent to the advocate for the child or the guardian for the child. Now, we've got an advocate for the child appointed, but the minister says that this Verfahrensbeistand does not represent the child in the proceedings. So that terminology is incorrect, the way that it's currently translated into Italian. Also in France, similar terminology is used. The whole point is the following. If you have court proceedings where a guardian is appointed, it is because the parents, rightly or wrongly, have been stripped of some of their rights as parents vis-à-vis the child. So in that case, in France and Italy, that would be the case. But it's not the case in Germany. In Germany, you have a Verfahrensbeistand when there are two parents involved who have full rights vis-à-vis their child. So you'll understand that if I use the term guardian, or the Italian term tutori, it's undermining the status of the parents. And it's not just that this is an erroneous translation, there's also a highly misleading translation. There's also the term Beistandschaft. That is something which in our systems does not exist. So there's no point trying to translate it with similar terminology, because that will undermine the legal statement. It might mean that the text reads well, but it's problematic. The same for Grundgesetz. There isn't a German constitution as such. There is the basic law. Each of the 16 federal states has its own constitution, says the speaker. So, the Jugendamt, that's a term that should not be translated. It has powers which are very different from those of the Youth Welfare Service or a social service. These are bodies that exist in other member states, but the Jugendamt has different powers and competences. As the Jugendamt has specific legal powers, it should be left with its specific German name, to make that clear. And if you can't pronounce Jugendamt, you can always say Administration for Young People or Agency for Young People. But there's no protection included in the term Jugendamt as a term. Here you'll see that I've explained there's the staatliches Wächteramt, state control authority. That's not at all the same thing as state oversight. And that's actually the definition which the Jugendamt gives of itself. It's a state control authority. That's what the minister says in that letter that I referred to earlier. So it's very important to translate these terms as I have indicated here, and always to translate them the same way as well, of course. We, of course, can discuss which terms we think might be better or worse, but we have to agree on basic vocabulary. You can't just use the terms that you would generally use. You can't just use the terms such as an advocate for the child or a guardian, because that simply doesn't correlate legally. It would be legally erroneous to translate it in these terms, and you'll end up talking about two different things, and that's the reason why. For example, if you look at these terms, these are also terms that we don't have. In Germany, these terms do exist. There is, for example, elterliche Sorge, parental responsibility. There is two aspects of this. There's care for the person of the child and care for the property of the child. Personensorge and Vermögenssorge. And that's impossible for us. Everyone says to me, well, what do you mean about the property of the child? What kind of property does a newborn child have? But I've been told that elterliche Sorge is divided into these two categories, Personensorge and Vermögenssorge, care for the person and care for the property of the child. So we had this letter from the minister, but when it's translated with the terms that we normally use, it doesn't make any sense. The same goes for the term Sorgerecht. Asking what the legal definition of Sorgerecht is didn't make any sense in that letter. What we have to do to resolve these problems then is to look at the situation in detail, in particular studying the code of procedure. And that's really what makes a difference. I've written a book about all of this, as a matter of fact. I've analysed Italian ratification of the convention, the Hague Convention, and also the way in which that was ratified in Germany. Now, looking at the Italian version, looks as if all of the children were to be really sent abroad of executive repatriation, no appeal, that's that. Germany did the exact opposite, quite clearly in the way in which it ratified this. So if a child is taken illicitly to Germany, well, never mind, the child will be there and remain there because, first of all, you have to explain that the child has been sequestered. There is this notion of what Severine said as well. If she'd been a German mother, she could have acted with impunity. Master Tuni also addressed this point. If a child had always lived in Italy and was taken to Germany illicitly, after 3 months, the Jugendamt will say the child speaks German perfectly, and therefore you must obey the Kontinuitätsprinzip and keep them in Germany. And even if you obtain a repatriation decree, well, that was all fine and dandy, but you have to ensure that that judgment is enforced, and such enforcement is not automatic. First of all, you have to have a judge hand down such a ruling will be enforced for only after 15 days. So that means that there's time for the other parent to appeal and impede this. And if the parent loses that appeal, then, once again, the enforceability of this judgment may be suspended. It may be suspended multiple times, infinite number of times as a matter of fact, until sooner or later you end up at the German Constitutional Court, and they will then say, well, the child has been sequestered, has been kidnapped, but now after 5 years, well, that's that. So it's the code of procedure which makes such a difference. Regulation 4/2009 is very striking. Alimony is paid, benefits are paid from other countries to Germany, but not vice versa, because this can all be suspended vice versa when money is to be paid to other countries. It's absolutely essential that we look at the various different pieces of legislation and get a clear picture of what is meant by the well-being of the child. But we also need to have a clear grasp of the code of procedure, because these are the points that really make a difference, and they tend to be overlooked. Another one important point that I wanted to underline, I'm being told that I have to speed up and come to a conclusion, over and above the fact that all these different protagonists, non-German national parents, face the following situation. So here you have the non-German parent and all of the other players opposed to them, seeking to keep the child in Germany. Furthermore, when the judge does not know how to proceed, he or she will nominate an expert. That expert, however, seems strange for us in our country, but that expert does not necessarily have a degree in psychology. Anyone can assume the role of expert. They just have to be one of the judge's mates, and then they can be appointed as expert. There's enormous discussion on this in Germany too, because in 75% of the cases, the experts do not have the prerequisites to be called experts. Furthermore, if you have the foreign parent there, the non-German national, they will be interviewed for the expert demand with an interpreter, and that would be studying psychological aspects. You cannot do this properly if you're working in a language that is not your own, it's not your mother tongue. The children will go to special schools in these cases. They're sent to special schools because they're said not to understand German.
I will ask you to quickly conclude, please, because we have 12 minutes left to do the conclusion and also the Q&A session. Thanks a lot.
So as I was saying, there's a problem of the experts and the fact that there's a non-adversarial system. It's not an adversarial system, as Ms. Evie said as well. In court hearings, often in our countries, 2 children are held on their own, but there are those special mirrors where you can see through in only one direction, and also it's all recorded. That's not the case in Germany. So you see these decisions, which are in a sense fabricated. They appear to respect all of the provisions in family law well-being of the child and so on and so forth, but it's the exact opposite. That is the reason why it's impossible for these parents to make any headway. For example, when it comes to appealing, if you have an expert opinion drawn up by an expert, instead of talking loudly to my child in Italian, they took the child away because that's apparently a child. I mean, the other courts are going to believe it if an expert decrees that this is the case. So it's important to understand the difference in legal terms and also in terms of the terminology used in the various different languages. Thank you.